Now, I want to get to those explosive allegations. Lori Vallow Daybell and her attorney, Mark Means, in the Doomsday Couple case. There they are when they were in court. Lori Vallow Daybell has been getting treatment because she's been found not competent to stand trial. So she's in the care of the Idaho Department of Health and Welfare, and they're trying to make her so she understands what's going on, trying to get better. She's getting counseling, and she's got a clinician who she works with. But now there are explosive allegations from Mark Means about a conversation that the clinician had with Lori Vallow Daybell that led to the LDS Church and ties it all together with the prosecutor, Rob Wood. Chanley Painter has more for us tonight.
Lori Vallow Daybell's attorney, Mark Means, has filed an explosive new motion detailing troubling allegations that his client, who has been deemed unfit to stand trial and is being held at a psychiatric facility, has been manipulated by her caretakers. Here's what the motion details. It says, according to her attorney, Lori is being treated by a clinician at the Idaho Department of Health and Welfare, and Lori and her clinician watched Chad Daybell's change of venue hearing together on October 5th of 2021. During that hearing, the clinician recommended that Lori contact the LDS Church headquarters legal counsel to discuss her case and possibly obtain new legal counsel. Now, the clinician reportedly provided her with the phone number and said that that would be part of Lori's treatment as a patient. The motion states that Lori would not otherwise have reached out to this legal counsel. And according to her attorney, Lori didn't want to make the call. She felt forced. Lori did call the LDS headquarters and spoke to attorney Daniel McConkey. She reportedly, according to this motion, told him the story, the details of her case, and allegedly made Brady violation disclosures under the guise that the church was her friend and that they were there to assist her. Now, Means insists that Lori would not have made the disclosures without this attorney, McConkey's, assurances that he already knew every detail of her case, and McConkey never disclosed any conflict of interest or that her conversation wouldn't be covered by the attorney-client privilege. Well, McConkey allegedly, according to this motion, called the prosecutor over Lori's criminal case, Rob Wood, and gave him the details of what Lori told him in this phone call. And once Rob Wood alerted the defense, this motion alleges that Rob Wood is minimizing what that discussion entailed. This motion is requesting the judge in the case to conduct an exhaustive, intense investigation to get to the bottom of this. It's asking for certain subpoenas. It's asking to disqualify the Idaho Department of Health and Welfare, and of course for the prosecution to hand over any Brady material or evidence gleaned from that conversation. And that's the latest in the Doomsday Couple case. I'm Chanley Painter with Court TV.
There are a lot of things wrong with this. There are a lot of things wrong. I don't know if it's enough to overturn the case or get the prosecutor booted from all of it, but why is the clinician giving advice to Lori Vallow Daybell to call an attorney? And why on earth is that attorney then calling the prosecutor and talking about anything, even mentioning that Lori Vallow Daybell called him? You're an attorney. You know, someone who's charged in a criminal case calls you and you consult with them, you have a conversation. You should not be sharing that with the prosecutor or anyone else, unless Lori Vallow Daybell wants you to, but she's been deemed not competent. This is bizarre. Now, let me put up on the screen. This is what Mark Means is saying, and the biggest allegation he's making. He says it strains credulity to ignore the facts that the LDS Church/corporation and its legal counsel are possibly involved and are working with the state/prosecution/Idaho Department of Health and Welfare, at least in this instance, to manipulate defendant to be forced and manipulated into statements against her interests. These are alleged admissions that she's making to this LDS attorney. These behaviors, if true, are clearly unethical, I agree, and possibly illegal activities to undermine the defendant's constitutionally protected rights. Now, the prosecutor did respond. I want to put the response up there. And again, I have no idea if Rob Wood just got a phone call. I don't know how he reacted to it. I don't know what he heard or didn't hear. But I'm flabbergasted by the actions of the other two. Here we go. The prosecuting attorney statement. The state will continue to focus on pursuing justice on behalf of the victims. We will address the unfounded claims by one of Ms. Daybell's defense attorneys in a court of law, not in the media. Filings of this nature are traditionally sealed and handled in confidential proceedings. Litigating such matters publicly can compromise both parties' right to a fair trial and compromise various individuals' rights to privacy. The mental health issues and investigations are not suited for the court of public opinion. That's from Lindsay Blake and Rob Wood. I disagree. I think all trials should be public. Everything should be public unless there's some major reason to seal things. It's a public trial. Anyhow, let's bring in our think tank, get some reaction to all this tonight. Joining us in the Bronx, New York, criminal defense attorney Renee Hill. In Houston, Texas, criminal defense attorney Carmen Rowe. And in Atlanta, Georgia, criminal defense attorney, law professor at Emory University, and Georgia Innocence Project board member Molly Parmer. Great to see everyone tonight. I'm going to start with you tonight, Molly. Is this crazy? There's something crazy going on here.
I think it's shockingly unethical, and maybe something really nefarious and crazy is going on, okay? I mean, the fact that, so what she's doing with the Department of Health and Welfare is she's supposed to be having her competency restored. They are not supposed to be advising her on changing lawyers or assisting her in contacting some attorney who certainly did not have her best interests at heart and doesn't represent her and doesn't have confidentiality with her. I'm very suspicious of this clinician who facilitated this contact with the LDS lawyer, and I have no idea why a lawyer would then call the prosecutor. I feel very suspicious of the whole thing, and it might be a conspiracy.
Carmen?
I believe in conspiracy theories. Look, the Idaho Health Department is an arm of the state. So to suggest that they are an independent body in this situation is not real. So I'm with Molly. They have to have a hearing on this, that these allegations are unfounded. From the prosecutor is what he says, they're unfounded. I mean, we know that communication occurred with a defendant represented by counsel, outside of counsel, while in treatment, and that information was conveyed to a prosecutor in this pending case. So it's not unfounded. What we need to do is have a hearing to determine how this conversation was elicited from this defendant, who communicated the information she gave, under what circumstances, and then whether or not that information can be suppressed or should be suppressed, because her right to silence is something that is constitutional, and I think that it's been impugned in this case, no question.
Now, Renee, I don't believe that Rob Wood the prosecutor was, controlling all this. I mean, some people may believe that, and maybe there'll be evidence of it. I just don't, my instincts say no. My instincts say someone just called and we picked up the phone. But if he learned anything in that phone call, which again, he's saying he didn't, that's trouble. That is big trouble here.
It is a lot of trouble. It's quite disturbing, and I completely agree with Molly and Carmen that the conduct here is reprehensible. No one should have been speaking to Lori at all, especially an attorney who's then gleaning information and then calling the prosecution to give them that information. And when Mr. Wood received that phone call, when he realized what was being said to him, he should have ended the phone call. And now anything that comes out of that is in jeopardy here. Yeah. And it creates a problem for this case. And certainly if she is deemed to be competent at some point and goes to trial, and if there is a conviction, you better believe that all of this is going to come back up, and it's going to put any guilty verdict in jeopardy as well.
All right, let's start with the clinician. I'm thinking maybe if there's no conspiracy and she just didn't know, she or he didn't know better, right? Just didn't know, okay? They're oblivious to the law and everything, and they just don't know. Okay, but an attorney who gets a call from a criminal defendant, Carmen Rowe, you get a call out of the blue from a criminal defendant who's been charged with murder, and they start telling things to you. It seems to me it would undermine our entire system if you could then, as an attorney having a conversation with a criminal defendant in a murder case, could then take whatever they say and just blab it straight to the prosecution.
No question, Vinny. My first call after that one would not be to the prosecutor in the case. I mean, I think McConkey, who's the lawyer in this case, who received the information and then transferred it, he is in a world of trouble. Everything about what he did was unethical, from not telling Daybell or whoever communicated for her that he was an attorney, that he had a conflict, that he didn't represent her, that she should talk with his attorney. I mean, these are all things we learn in law school. And when you don't follow them, you've committed an ethical violation and you're subject to discipline as a result. And then for him to turn around and call the prosecutor, I mean, that's a no-brainer. That is something that should and will get him in hot water.
Molly, what's the remedy here? Let's say that there was some information that was transmitted to the prosecutor. What is the remedy here? What would the court do? What do they have to do?
Depending on what that information was, if it is material to her defense, for example, if it is something that should have been protected and confidential and now the prosecutor knows, I think we need a whole different, not just a whole different prosecutor, but a whole different office. Maybe it has to be relocated. We've already changed the venue once in this trial, but we may have to start all over again, depending on what was disclosed to Mr. Wood.
Renee Hill, what if nothing is disclosed to Wood, but just to this attorney by the clinician? Then what do we do? Does the court do anything?
Well, her rights are still violated here. And so they have to have a full hearing and vet these people and find out exactly what was disclosed here, what these people know.
Let's say she makes some she made incriminating statements to the clinician, basically admitting that she took part in these murders and knew all about it and helped plan them. If she made that admission to the clinician gives that to the LDS attorney, but the prosecutor does not get that information. It just goes to the LDS attorney. Is there any harm to Lori Vallow at that point in terms of her rights at trial?
I still think there's harm there, absolutely, because now she has made an admission to someone who she may have believed at the time had her conversations in confidence and that it wouldn't be disclosed. These people can now turn into witnesses against her, and she was in the care of a mental health facility at the time, and her attorney was not present. It seems as though they were acting as the arms of the officials here, and even if not, she has been compromised, not willingly.
I just don't understand how this happens. This makes no sense to me. This is bizarre. It makes no sense at all. Has anything even close to this ever happened in a case that any of you have handled?
No.
I've only had instances where prosecutors have done things where they potentially made themselves a witness to a case, and we've had to argue that in front of the judge as to why they should perhaps be removed because we might want to call them now as a witness. But something like this, where we have health facility, suggesting that she change counsel and encouraging her to change counsel, this is insane. They're the ones who need to be evaluated at this point.
All right, we'll continue to follow this and figure out where it goes. I mean, this could be a major problem for prosecutors if, in fact, these allegations are true.